All right, good morning, everybody. We're on the April 21st, 2023, 9:30 a.m. docket. We have the Pill Club Pharmacy Holdings, LLC case 23-41090, and ostensibly subject to our motion for joint administration, we have the affiliated cases, which include Hay Favor Inc., case 23-41091, Moby Meds Inc., case 23-41092, MedPro Pharmacy LLC, case 23-41093, FVR Medical Group Inc., case 23-41095, FVR Medical Group of Texas, PA, case 23-41096, FVR Medical Group of Kansas, PA, case 23-41098, and FVR Medical Group of New Jersey, PC, case 23-41099. Let me start by pulling up my screen here. There we go, and we'll start by taking appearances of counsel. And let me just note for you all that we have had a couple of electronic appearances that we're aware of. Let me just tell you all what we have on that front so that those folks don't need to make a formal appearance if they don't wish to. We have Mr. McGuire on behalf of the debtors, and we have Mr. Brandsburg on behalf of Amerisource Bergen Drug Corporation. So with that said, let me go ahead and open the floor to additional appearances, and we'll start in the courtroom. Mr. Helt.
Good morning, Your Honor. Marcus Helt on behalf of the pre-petition lender. My partner, Darren Osmond, is also on the phone. Darren and I represent the lenders, TriplePoint Venture Growth BD, C Corp, TriplePoint Venture Lending Fund, LLC, and TriplePoint Private Venture Growth Credit, Inc. Mr. Osmond will run point for our side, and I'll just be here to assist.
Okay.
Thank
All
you,
right.
Your Honor.
Good morning to both of you. Who else do we have? And I'm going to try to direct a little bit of traffic here because I know we've got some level of folks on the line today. Who else do we have today on behalf of the debtors?
Your Honor, if I may, Tim Walsh from Winston & Strawn on behalf of the debtors, proposed counsel for the debtors. As Your Honor mentioned, Dan McGuire from my firm is also on, as well as Emma Fleming. We will all be making appearances. I believe our Pro Hocs have been filed. If not, they will be filed today. Hopefully Your Honor will indulge us for the purposes of today's hearing. Katie Preston from our Dallas office is also on as well, Your Honor. From the company, Your Honor, Liz Meyerdurk is the CEO. She is also on virtually, as well as Christine Park, who is the CFO, and Lauren Darius, who is the general counsel. Brandon Beal is on from Accordion. Accordion is the financial advisor, proposed financial advisors to the company. I think I have everyone from the debtor side, Your Honor.
Okay, very good. Thank you. Good morning to all of you. And let me just let you know, I know that I have granted the Pro Hoc applications that you all have submitted, but for the benefit of others, for other parties in interest who may be on the line, if you have pending Pro Hoc Vice requests with the court, pardon me, that have not caught up to me yet, or if you just frankly haven't had the opportunity to be able to get that on file because of the expedited nature of the hearing, please go ahead and consider yourselves admitted for purposes of this hearing so that we don't have anybody not having the opportunity to appear on behalf of their clients for purposes of this hearing. So, all right.
Your Honor?
Please.
Yes, Tina Marie File from BMC Group, proposed claims and noticing agent for the debtor. Just here in case there's any question on our application.
Okay, great. Thank you. Good to have you. All right, who else do we have wishing to make a formal live appearance for today's hearing?
Your Honor, good morning. It's Darren Asman, as my partner, Mr. Helt mentioned, from McDermott Loan Emery on behalf of TriplePoint.
Okay, good morning.
Good morning, Your Honor. It's Michael Yerkowitz of Claire Harrison, Harvey Brandsburg, on behalf of Amerisource Bergen, along with Mr. Brandsburg. Not sure which one of you will be hearing from, but one of us. Thank you.
All right. Good morning to you as well. Give me 1 second. I'm just taking notes. All right, any other live appearances?
Good morning, Your Honor. Meredith Kippis on behalf of the United States Trustee.
All right, good morning, Ms. Kippis. Good to see you back.
Good to see you, too.
All right, any other appearances? All right, then, Mr. Walsh, let me turn it over to you to direct traffic here this morning and tell us how you'd like to proceed.
Thank you, Your Honor. Your Honor, what I thought I would do is give a brief introduction on the company's operations, some of the events leading up to the filing, where we are, where we think we're going to go, and then jump into some of the first days. We're having somewhat of a truncated first day hearing. We've been negotiating in good faith with our lender, TriplePoint. We did reach a little bit of an impasse yesterday on the budget, and so what we decided to do today, instead of having a contested cash collateral battle, that we would go forward today with what we absolutely necessarily need for funding today, and that's payroll, and that's the only expenditure we'll be looking for approval today. And then come back to Your Honor next week, hopefully with a complete cash collateral motion, order, and budget that sets the pathway for the case going forward, all on a consensual basis. That's the goal, Your Honor. But for today's purposes, and you'll hear more about that later when Mr. McGuire addresses the court on the cash collateral issue. So I thought I'd just give you a little background on the operations, and then we can jump into and give the roadmap as to where we're going, and then jump into the few first days that we need to get through, if that works for the court.
All right, that sounds good.
Okay, so Your Honor, the Pill Club is the nation's largest online provider of contraceptives, offering over 120 brands of birth control, emergency contraceptive, and female condoms to patients all over the country. And since the company's founding, it has served over 3 million patients. One thing that's very important to point out, this company does not sell the medical abortion pill. It never has, and it never will. I just want that to be clear on the record. The Pill Club is able to support its entire patient base, Your Honor, completely virtually. It has an arm that is a nationally licensed pharmacy. Actually, they operate out of 2 locations, and they're able to fulfill prescriptions throughout the entire United States. With the Pill Club technology, patients don't have to go to the doctor's office, get a prescription, then go to the pharmacy, wait for it to be filled, go back to the pharmacy and pick it up. It's all a one-stop shop, and it's all done virtually. And collectively, Your Honor, the debtors have approximately 220 employees. The debtor's lender is TriplePoint Capital, as you've heard, Your Honor, and we owe them approximately $30 million. Some of the events leading up to these Chapter 11 cases. So there was extensive litigation with various entities, and that litigation took a toll on the company, and that's really why we're here, Your Honor. And you'll hear more about those cases throughout this case, Your Honor. Currently, there are 3 pieces of litigation that the company's dealing with. An arbitration demand by CVS, a class action complaint, and an investigation by Michigan's AG's office. We'll be in contact with the AG's office, and we're going to ask for some additional time to respond to some of their investigative requests. Hopefully we'll get that consensually. If not, we may have to come back to this court. Really just trying to get a little bit some breathing room, Your Honor, right now to get a sale process underway and hopefully come to fruition pretty quickly in these cases. And understanding that we would not seek to stay that litigation, but just maybe to get a little more time. I just want to highlight that for Your Honor in case we have to come back to Your Honor on that front. So these legal actions, Your Honor, over the years really slowed down the company's ability to open up new business lines and to obtain financing and also to pursue strategic alternatives. And as a result, the board considered its options and alternatives at this point and decided that filing a Chapter 11 and trying to do a successful 363 sale was the best way to preserve assets for the benefit of all creditors in the case. So a couple of very important facts for Your Honor. So current management, the people that I just introduced you to, have only been at the company for 2 years. They arrived after all the allegations were made against this company. They inherited the company's problems. They didn't cause them. Management here is extremely important to ongoing operations. This is not a turnkey company, Your Honor. There are complex systems in place that provide services to hundreds of thousands of patients. Management is desperately needed for continued operations, negotiations, correspondence with potential purchasers, and perhaps more importantly, a transition of this company to a new purchaser. They are all highly qualified people that could easily leave and get jobs elsewhere. And you probably could envision this coming, but the board has approved a retention plan with real milestones for each of them. So we'll file that in the next day or so. So you'll hear about each one of these individuals, what they do, and why they're needed for the successful sale of this company. As I said, with respect to TriplePoint, Your Honor, we did reach an impasse on our negotiations with the budget and with consensual use of cash collateral. I would like to say we're very close. We have a very close relationship with TriplePoint and also with the McDermott firm. Cautiously optimistic that we'll be able to come back to Your Honor next week with a consensual order for use of cash collateral. But for today's purposes, we're only going to seek to use cash collateral on a consensual basis in connection with our wage motion. And I think it's approximately $800,000, but Ms. Fleming will enlighten the court on that in a few minutes. Your Honor, we're also talking to TriplePoint and others about providing DIP financing to cover shortfalls. That should be filed in the beginning of next week once we either reach a deal with TriplePoint or a third party, hopefully over this weekend. Your Honor, pre-petition, the Bank of America was in and conducted a marketing process. That relationship has been terminated, and the debtors are going to seek to hire new investment bankers that have more familiarity with this industry and this space. We do have a stalking horse, Your Honor, at this point for the sale of the company for $30 million. A definitive APA bid procedures and a sale motion should be filed at the beginning of next week as well. We're finalizing the APA as we speak. Hopefully that will be done over the weekend, and we'll be able to get a sale motion and an auction motion on file. Over the course of the last couple of days, we've had extensive discussions with Ms. Young, U.S. Trustee's office, and have shared all of our first days with her. We have gotten comments from the U.S. Trustee's office. All of them have been incorporated. As recently as this morning, I believe Mr. McGuire had some conversations with Ms. Hipps, and I think everything with respect to the U.S. Trustee's concerns have all been satisfied at this point. Your Honor, there's a declaration of Ms. Meyer-Dirk on file. I would submit that in support of all the first day motions that are going forward today. I will represent to the court that if called to testify, she would testify that all the facts to the best of her knowledge in that affidavit, in that declaration, are true and accurate. So I would submit that to the court. She is available for cross-examination if anyone has any questions in connection with any of the first day motions. But with that, Your Honor, if you don't have any questions, I'll turn the virtual podium over to Ms. Fleming, and we can start with some of the first days.
All right, very good. Thank you very much. Why don't we go ahead and just, as a housekeeping matter, take up the one point, which is we have the request effectively for the admission of the declaration of Elizabeth Meyer-Dirk for in support of the first day motions, the declaration having been filed at docket number 26. Is there any objection to the admission of the declaration, subject, of course, to the opportunity of cross-examination, I guess, kind of as we get to any particular motion? All right, then without objection, the declaration will be admitted. And let me, I guess, at the risk of disrupting a little bit of the flow, because it was a very helpful and somewhat detailed background introduction. Let me, I guess, just at least open the floor to see if there are any other parties in interest before we get into the meat of our subject matter for today. Any other parties in interest that wish to make any very high-level introductory comments to the court in relation to the report that I just got from Mr. Walsh?
Hi again, Your Honor. Darren Asman from McDermott for TriplePoint. I would like to make just a very brief statement, if that's okay with Your Honor.
Certainly.
Your Honor, TriplePoint is the sole senior secured lender here, and we're owed around $30 million, at least, plus interest. TriplePoint also has a lien on substantially all the debtor's assets, including all the debtor's cash. As Mr. Walsh indicated, we've been in around-the-clock discussions with the debtors to try to negotiate for the consensual use of cash collateral and potentially a DIP. Also, as you heard, unfortunately, we're not there yet on the budget. And to be candid, I don't know if we will get there. I certainly hope we do. We, of course, want to make sure that employees are being paid, being paid. So we've consented to the use of our cash collateral to make sure that happens for this week's pay cycle. But that's it. Nothing more. We'd like a bit more time to work out a budget to see if we can get it done. And so we're going to do that between now and whenever we're able to get on your calendar for next week. Thank you.
Okay, thank you. Any other comments?
Please.
Go ahead.
Yes, this is Mark Brandsburg, representing Amerisourceburg and Drug Corporation. Thank you for allowing us to appear. Your Honor, we're a small player compared to TriplePoint. Our client is a distributor of pharmaceuticals and has been a distributor to two of these debtors for a significant period of time. Our client is owed $100,000, in total broken up between MedPro and the Pillbox. We believe that we have a senior secured position on inventory that our client has sold to MedPro. We have a UCC that's filed 2020, and I believe that that's senior to TriplePoint. It's a limited security interest, and it's limited to inventory that our client sold to MedPro. All of that inventory, as well as the inventory sold to the Pillbox, is within 20 days prior to the filing, so it's 503B9 claim. I spoke to Mr. McGuire shortly before this hearing, and he indicated that none of the cash collateral to be used to pay payroll will be cash collateral of Amerisourceburg, so we have no objection to using the cash collateral. But we just wanted to let the court and parties know of our position, and I'm sure that over the next few days we can determine whether or not there's any issue with respect to our position. Thank you, Your Honor.
All right, thank you.
And Your Honor, of course, the debtor has no problem. The debtor will cooperate and will investigate whatever position they think they have. So, not an issue.
Okay. Any other high-level comments from anybody before we get into the granular? All right. then I think, Ms. Fleming, you are up.
Thank you, Your Honor. Can you hear me all right?
It's a little bit faint, so you might have to just kind of lean in a little bit and just talk a little unnaturally loudly, but we'll make
Okay.
it perfect.
No problem. Is that any better?
It is much better. Thank you.
Okay, great. I'd like to just start by briefly thanking the U.S. trustee who was able to mobilize very quickly this week in reviewing some motions and speaking with us and getting us their comments. I believe that all of the orders are substantially acceptable with a couple of minor issues that the United States trustee might raise today. So we were able to file an agenda last night, and we're going to skip through a couple of items because of the cash collateral issues outstanding. So the first item that we're going to go through is our joint administration motion, which was filed at docket number 5. The relief sought in this motion is the procedural consolidation and joint administration of these Chapter 11 cases. As set forth in our motion, all of the debtors are affiliates, as that term is defined in the Bankruptcy Code. And at this stage in the proceedings, the debtors believe that any sale of the company or any reorganization would likely involve all of the entities, and therefore joint administration will save money and time and avoid duplicative and potentially confusing filings by permitting counsel for all parties in interest to use a single caption and file papers in one case instead of 8. And further, creditors' rights will not be adversely affected by joint administration, and therefore joint administration is appropriate in these cases. We believe the U.S. trustee is supportive of the relief requested in this motion, and we have not received any other objections. And accordingly, Your Honor, unless the court has any questions, we would submit the joint administration motion and proposed order to this court for entry.
Okay. I do not have any other questions. Does anybody else wish to be heard with respect to the joint administration motion?
Your Honor, Meredith Kippis on behalf of the United States trustee. I just want to confirm Ms. Fleming's representation that the U.S. trustee does not oppose the joint administration motion.
Okay, great. Thank you. All right. Any other comments? All right. Then, having reviewed the motion, it does seem appropriate and warranted and sufficient cause to grant the requested relief, so the relief will be granted. I'm also going to just dive in at this point and take one matter that isn't really designated on the agenda, but does sort of dovetail with the joint administration, and that is, I will just simply note that now that we have joint administration of the cases, I will also approve the designation of the jointly administered case as a complex Chapter 11 case under our complex rules. So we will, if you'll just go ahead and Ms. Fleming coordinate in conjunction with uploading the joint administration orders, which will need to go into each of the individual cases. Also upload the complex Chapter 11 order so that we can get that entered in the, once we have the joint administration orders entered everywhere, that one can just be uploaded in the jointly administered case, and then we'll get that entered as well, and then you'll be off to the races with respect to the procedures under those rules and can coordinate. I mean, I know we're going to talk about a setting next week, but as a general proposition, you'll be able to coordinate with my courtroom deputy, Ms. Reuter, on getting special settings for future hearings to the extent that you want to go ahead and pin those down in advance. Okay?
All right, that makes sense. Thank you, Your Honor. Okay, the next item on our agenda was our schedules and statements extension motion, which was filed at docket number 8. And by this motion, the debtors are seeking an extension of their deadline to file their schedules and statements by up to an additional 42 days, up to and including June 13th, 2023, which totals 56 days from the petition date. And this date will be 7 days prior to the meeting of creditors that has been set by the U.S. trustee and scheduled for June 20th at 1:30 p.m. We've conferred with the United States Trustee's Office, and the U.S. trustee has indicated that they are not opposed to the relief in this motion. And accordingly, Your Honor, unless the court has any questions, we would submit the schedules and statements extension motion and proposed order to this court for entry.
Okay. Does anybody else wish to be heard with respect to the motion for an extension of time for schedules and the statement of financial affairs?
Meredith Kippis for the United States Trustee. Your Honor, I want to confirm that we do not oppose the extension of time to file schedules and statements of financial affairs until June 13th, 2023. The Section 341 meeting in this case is set for June 20th, 2023 at 1:30 p.m. It will be a telephonic meeting like we've been doing since COVID hit us all. And I wanted to take the opportunity now to let the court know that the committee formation letters went out on April 19th, and the committee formation information, including a PDF of the solicitation letter and form, has been posted to the U.S. Trustee Program Region 6 website. If anyone on the call who did not receive it from us, either via email or regular mail, would like to go and look at that.
Okay, great. Thank you. All right. Then with that report, which I appreciate, I will grant the requested extension of time. And if you'll go ahead and arrange for an order to be submitted on that one as well, we'll get that entered as soon as we see it.
Great. Thank you, Your Honor. The next item on the agenda is the debtor's cash management motion, which was filed at docket number 9. And the relief sought by this motion is the continued ability to operate existing bank accounts, the maintenance of existing business forms, and the continued ability to engage in intercompany transactions in the ordinary course of business. In this case, the debtors operate 11 bank accounts, 10 of which are with First Citizens, which was formerly Silicon Valley Bank, and the final account is with Bank of America. Bank of America is an authorized depository with the U.S. Trustee's Office for the Northern District of Texas. And in addition, yesterday morning, the U.S. Trustee confirmed with us that those former Silicon Valley Bank accounts at First Citizens could be converted into DIP accounts. And so the proposed financial advisor team at Accordion worked yesterday to get this done, and we received confirmation this morning that those accounts have been converted into debtor in possession accounts. In addition, the United States Trustee has asked the debtors if they would be willing to close their one existing money market account and their 3 existing investment accounts, which are all with First Citizens, which as of the petition date all held either no money or very minimal levels of cash. And the debtors have confirmed that they're happy to close those accounts, and they've reached out to First Citizens to begin the process of doing so. The final relief requested is that the debtors submit that once they've exhausted their existing stock of business forms, they will ensure that any new forms are clearly labeled debtor in possession. And we would just note, for your honor, that today is payday for the company, so we do need this relief in an emergency fashion in order to make sure that the payroll processor at ADP can sweep those funds. The payroll that's due and owing is approximately $846,000. We believe the U.S. Trustee supports the relief requested in this order, and we have not received other objections to this motion or order. Accordingly, Your Honor, unless the court has any questions, we would submit the cash management motion and proposed order to this court for entry.
All right. Ms. Kippis, tell us, U.S. trustees on board, is that correct?
Yes, Your Honor, and we are very pleased to hear that the First Citizens / Silicon Valley Bank accounts have been able to be converted to DIP accounts. The court surely knows that the word Silicon Valley Bank raised some alarms, but I'm happy to hear that First Citizens has worked with the debtor get those accounts converted to DIP accounts. It's really, really good news. We appreciate the debtors agreeing to close investment accounts in the money market account. And yes, Your Honor, Bank of America is on the authorized depository list in Dallas. Another part of the relief that we had agreed to, which I think may be irrelevant now, was an extension of time to comply with Section 345B if necessary, and we had agreed to an extension of time of 45 days, but it seems like that might not be necessary now. But we did agree to it, so just wanted to put that out there. And finally, Your Honor, yes, they can use all existing business forms with no problem at all. And so happy to say that the U.S. trustee agrees with this relief.
Okay, great. Any other parties in interest wish to be heard with respect to the debtor's cash management systems motion? So let me ask you all one thing, which it wasn't entirely clear to me, and maybe I may have just missed it because it's still a little difficult to hear, and I'm not suggesting, Ms. Fleming, that you need to do anything. It's the nature of the beast with remote hearings. But with the things that you all have managed to accomplish collectively with the U.S. Trustee's Office, are we still looking at an interim order, or are we now to a point where this can just be a one-time order? And I'm really kind of asking both of you, but let me start with your understanding, Ms. Fleming.
So we had drafted it looking for interim and final because First Citizens was not on the authorized depository list as of January of this year. So just out of an abundance of caution, even though Silicon Valley Bank was on that list. But now that they've been converted to debtor in possession accounts as of this morning, if we could just enter final relief, I'm sure that would save some administrative headache for the debtors, if the U.S. trustee would be okay with that.
Okay. Ms. Kippis, what do you think?
Your Honor, given that all of the accounts are being converted to DIP accounts, and I believe 4 accounts are being closed at our request, I think a final order is fine. I'm not sure the 45-day extension is staying in the order, but if it is, that can be in an interim order, that can be in a final order. So I think we're probably fine here.
Okay, all right, so why don't I do this? I sort of assumed that maybe we had gotten from A to B on that, but let me just leave it to you all. I'm fine either way. I just raised the issue because it sounded like the typical extra time that would be needed to deal with stuff maybe was becoming moot. If there's still things that need to be, I's that need to be dotted and T's that need to be crossed, we can certainly do an interim order, but like I said, I'll just leave it to you all to compare notes after the hearing, and if everybody's comfortable on just submitting a one-time order, I'm just letting you know I'll be happy to enter an order on that basis. But again, if there's just still some things that maybe need to be tied up to make sure it's all clean, we can do an interim order as well. It's really whatever you are both collectively comfortable with. And just for purposes of our record, I'll note that obviously this type of relief, now that we're getting into the more substantive relief, I do find cause for immediate consideration in considering the limitations under Bankruptcy Rule 6003, such that immediate consideration is appropriate, and that the waiver of all applicable stays to the effectiveness of the order upon entry will be waived so that the order can be immediately effective upon entry. Well, again, we'll look for an order. I know you said you need it ASAP, so however you all want to do it to get the order entered ASAP, we'll look for the order, and once we see it, we'll get it entered. Okay?
Thank you, Your Honor. And we're not trying to put the U.S. trustee on the spot, so we'll make sure that we chat after this hearing before we upload anything to the court.
Perfect.
Thank you. We're actually going to skip the next couple of items, we're going to skip the insurance motion for today, which was filed at docket number 10. We're going to skip the taxes motion, which was filed at docket number 11. And we're going to skip the utilities motion that was filed at docket number 12 and move right along to the wages motion, which was filed at docket number 13. As we explained previously, today is payroll day, so we do need this relief today. The relief sought in the debtor's wages motion is twofold. It's the authority to pay pre-petition wages, salaries and compensation, and other reimbursable expenses, and the authority to continue benefits programs in the ordinary course of business. So by this motion, the debtors are seeking to pay their amounts owing for their approximately 222 employees. As set forth in our motion, the debtors seek to pay pre-petition amounts related to wages, independent contractor compensation, withholding obligations, reimbursable expenses, and employee benefits, including medical, dental, vision, life, short and long-term disability insurance, 401k deductions, and PTO amounts owing. In addition, while there are no pre-petition amounts accrued for workers' compensation, COBRA, or other miscellaneous benefits, the debtors do request the authority to continue those programs in the ordinary course of business. The total amount that is due as of the petition date for under the debtor's wages motion is approximately $1.4 million. We believe the U.S. trustee supports the relief requested in this order, and we have not received any other objections. Accordingly, Your Honor, unless the court has any questions, we would submit the employee wages motion and proposed order to this court for entry.
All right, let me, I'm going to couple this because now we're kind of getting into a little more substantive matters. Is there anybody who wishes to be heard with respect to this matter and or wishes to cross-examine Ms. Meyer-Dirk on the factual assertions that are effectively supported by the declaration in connection with the motion?
Your Honor, Meredith Kippis on behalf of the United States trustee. I do not wish to cross. However, I do have a couple of comments. The U.S. trustee is supportive of entry of a wage order. We have one little request, and I'm not sure if it's made it into the last version of the order or not, that there was a request in the motion to be able to implement new employee programs. And we requested that to the extent new employee programs might be subject to Section 503C, that be done by separate motion, and that they not be able to do that just in the ordinary course of business. Other than that, all our other questions, comments, concerns, requests for information have all been satisfied.
Okay. Anybody else wishing to cross-examine or wish to be heard? All right, and let me just take a look here. So, Ms. Fleming, let me ask you, I'm looking at, it looks like you have some language in paragraph 2 of the proposed order that was filed with the motion, but is there, I assume you all are on the same page. Is there any additional language that you all have been working through to just make it clear?
We added also a provision into paragraph 1, which limited the relief requested to to the limitation requested by the U.S. trustee, and we also added that the relief requested was subject to a budget, which was a comment, an agreed budget, which was a comment from the secured lender. So Both of those provisions are now in paragraph 1 of the proposed order.
Your Honor, Meredith, this is for the U.S. trustee. With that representation from Ms. Fleming, the U.S. trustee is satisfied. Thank you.
Okay, great. All right. Any other comments from anybody? All right, then obviously it's critical for us to ensure that employees are not concerned with respect to their continuing payment of wages and related benefits. Therefore, again, just for record purposes, I find that there is cause for immediate consideration of the motion in relation to Bankruptcy Rule 6003, and that there's certainly cause for the approval of the requested relief to ensure that there's no harm to the estate and that we can keep operations going. So I will approve the requested relief under the proposed form of order that has been presented, and also waive any deadlines that would be, waive any stay periods that would be applicable to the enforcement of the order, so it will be immediately enforceable upon entry, and adopt any additional findings that are contained within the proposed form of orders as the court's own findings. So if you'll have that submitted, we'll get that entered as soon as we see it.
Perfect. Thank you, Your Honor. Next on the agenda is the debtor's motion filed at docket number 14, which seeks threefold relief. It seeks to file under seal patient information. It seeks to file under seal certain personal identification information of employees. And it just seeks approval of the form and manner of the notice of commencement of these Chapter 11 cases. So taking these in turn, in the ordinary course of business, as Mr. Walsh has explained, the debtors prescribe and ship contraceptives to individual consumers. Accordingly, the debtor's operations generally must comply with HIPAA regulations. Most relevant here is HIPAA's prohibition on disclosure of individually identifiable health information, which includes even patient names. The penalties for disclosure of individually identifiable health information under HIPAA are severe, and they can include substantial fines and prison time. And therefore, the debtors submit to this court that any list of the debtor's customers to be filed in this case is required by law to be filed under seal. And the debtors propose that the sealed portion of any document, including a creditor matrix, that is covered under HIPAA should not be made available to anyone except that a copy would be provided to this court under seal. A copy would be provided to the U.S. trustee to be held in confidence under Section 107C3 of the Bankruptcy Code, as well as to counsel to any official committee appointed upon counsel to that committee executing a business associate agreement under HIPAA. The second prong of relief relates to the privacy of the individuals who work for the debtors. The debtors take the privacy of their employees very seriously. In addition to not being able to run afoul of HIPAA, the debtors do not want to be in violation of any applicable data privacy law or subject any individual to any identity theft or threat of harassment. And therefore, the debtors request that the sealed portion of the creditor matrix and any schedules and statements that contain information related to employees, but information that is not covered by HIPAA, should be provided by BMC, the proposed claims agent, to the court, to the U.S. trustee, and to counsel for any official committee appointed in these Chapter 11 cases, as well as to any party in interest upon a request to the debtors, but otherwise we would request that that be filed under seal. And we do believe that this portion of the relief is opposed by the U.S. trustee's office. But the debtors do feel strongly that given the disruption and the uncertainty to their employees' daily lives that have already been caused by these Chapter 11 cases, it is of the utmost importance to the debtors that they make every effort to protect the privacy of their employees during these cases. And the final form of relief in this motion is just that the debtors propose that the notice of commencement of the case be approved for service upon parties listed in the creditor matrix. And we have run this by the U.S. Trustee's office, and we believe that they're signed off on the form and substance of the proposed notice of commencement. And with that, Your Honor, unless you have any questions, we would submit the creditor matrix and notice of commencement motion to Your Honor for entry pending any objections from the U.S. Trustee's office.
All right, Ms. Kippis, let me, I guess, start with you and do what we've been doing, which is, do you wish to conduct any cross-examination, A, and then B, if not, just what the U.S. Trustee's view is with respect to the requested relief?
Your Honor, I do not wish to cross. The U.S. Trustee does not oppose redaction and seal of HIPAA-protected information, and the procedure suggested or requested to be approved by the debtors is acceptable with regard to HIPAA information. The U.S. Trustee has also reviewed the notice of commencement and has no comments and has no objection to that proposed form of order. Ms. Fleming is correct that we do oppose redaction of the employee addresses and other individual creditors to the extent there are any, as overly broad addresses and phone numbers are available on Google or in old-fashioned telephone books, which people are far more likely to go to than bankruptcy schedules for contact information. Junk mail companies have addresses, and there's no rationale really to redact any addresses other than those protected by statute. We recognize that there's a theoretical possibility that someone may be targeted, but we don't have any specific evidence of that here before the court. So we do object to that portion of the relief only as overly broad.
All right, does anybody else wish to be heard or wish to cross-examine? All right, look, Ms. Kippis, let me ask you, I know that there was, this issue seems to be coming up on a more regular basis, not on the HIPAA side of the equation, but more on the employee side of the equation. And I know that I think the U.S. Trustee's Office recently reached an agreement in another case that I have in the Tuesday morning cases. Do you happen to know what the ultimate concession was there? I just don't recall. The folks came and told me that they reached agreement, and I said, great.
Your Honor, unfortunately, I do not, because I am recused from that case because the law firm of Pulcinelli is and was involved, and as the court knows, I worked there very recently.
Okay.
So I don't know anything other than what's published in the newspaper with regard to that case. My apologies.
All right, so let's do this. I think that we've tried to, over the period of the last several years, tried to apply an appropriate balance in connection with these types of requested relief. But obviously, there are certain aspects of the motion that are not contested at all. So with respect to the form of notice, for example, that seems like everybody's in agreement there, so that's fine, that's approved. And the manner of getting stuff sent out is fine too. Really all we're dealing with is the question of the identification of potential parties in interest. And that's the real issue. And because when we're dealing with getting notices out to parties, that's something that needs to happen quickly. Again, just for purposes of our record, I'll note that it's appropriate to be considering this type of requested relief immediately for Bankruptcy Rule 6003 purposes. Let's start with the HIPAA-related relief. Obviously, the U.S. Trustee's Office is not opposed to redaction to the extent that it's necessary to ensure compliance with HIPAA. So I'm going to bucket that request first and agree that obviously we need to be consistent with HIPAA protections. Where it gets potentially tricky is we have sort of this distinction between an initial notice that may go out to a much broader universe, if you will, of parties in interest or ostensible parties in interest who may or may not end up being creditors. And so to a certain extent, sort of full redaction, I'm comfortable with, to the extent that we're sending notices out to folks who don't, at least from the debtor's perspective, don't hold a claim, okay? What we do probably need to do to make sure, frankly, it's for the protection of the debtors and the estates, is in relation to that bucket of notice, if you will. We still, at some point, will need something filed under seal in the court so that we have a court record of who's getting notice, just so that if something comes up later on, we have a good record of who's been provided notice. Where I was going with this is where it can get tricky is if we have certain patients, for example, who are known to be creditors, and how do you deal with those on the schedules? We can't really have fully redacted information on schedules, but that's the question is, how do we address identifying a creditor without necessarily identifying information as to the nature of the claim that would thereby trip a HIPAA wire, if you will. And I realize that's a bit of a challenge. I'm not going to try to regulate you all with respect to that because, quite frankly, when I was in practice, I was not a healthcare lawyer, and HIPAA is kind of a minefield. And I know that you have folks internally within your firm who know a lot more about what you can and can't do. I'm just going to simply note that we're going to need to have a way to distinguish between folks who are patients who are also creditors in the case, because if there is something that needs to be noticed out to all creditors, we're going to need to have a mechanism for whoever might be serving that to be able to get that information, as opposed to, for example, the notice to all potential parties who might later assert a claim, but we don't know yet, if that makes sense. Because with respect to that, nobody needs to know about that information. That's just getting information out to the patients, and if they determine that they think they have a claim, well then they are taking the action as opposed to anybody in the case needing to know the information. So hold that thought for a second, really with respect to the creditor bucket within the HIPAA bucket, if you will. And I'm going to come back to that in a minute. But I will just note that even for purposes of the schedules, while I said that I have concern about full redaction, I'm not telling you that you can't fully redact if the debtors in good faith believe that to comply with HIPAA that requires full redaction. I'm just noting that you may need to evaluate that and determine whether or not you think there's a way to list a known creditor that doesn't disclose information that would trip a HIPAA wire. Because if we know they're a creditor, we ought to try to list them so that it doesn't become unduly cumbersome in the case for parties to know what's going on. With respect to employee information, this has been an evolving challenge for the courts. I have probably been more flexible and more on the precautious side than maybe some of my other colleagues and have allowed some protection. I think that given the current environment within the country with respect to anything that involves reproductive rights, that there is an appropriate level, I think, of protection on the front end to be provided to employees, because while I appreciate Mr. Walsh's sort of emphasis, if you will, to clarify exactly what the debtors do and don't do, I'm not sure that the public's going to know one way or the other. And if we have potentially elements out there in the community who have an agenda that might not be aligned with the protection of individuals, we don't really want to risk that. So what I'm comfortable with doing with respect to the employees is, again, to the extent that we're not talking about employees who we think have claims, I'm okay with a redaction, kind of a full redaction notice going out to them. And again, that just needs to be filed under seal so that we have a good record of it. If we're talking about employees who the debtors believe have claims, what I think I would like to see is that their names ought to be listed and you all can redact the address information. Because again, we're talking about claimants, and on some level there is a public interest involved with the bankruptcy process. And so, you know, I realize that potentially creates some risk, but frankly, it's a lot less risk if somebody has to go hunt and try to find down, you know, John Smith, not knowing which John Smith it may be because the address is redacted. But still, you know, identifying who our claimants are if we're able to do that, which here I think we're able to do that without unduly putting them at risk. So that's very high level. Now let me tell you some exceptions that I think will apply going forward, and that is that once a claimant files a proof of claim in the case, I view that the protection, like go forward protections at that point are no longer required, because that's a voluntary subjection of the individual to the bankruptcy process without. Now, if they also redact, that may be a tricky situation, but certainly to the extent we have a proof of claim filed by any creditor that lists out all the information without any sort of redaction protection that's been allowed by the court, then I don't view that the go forward protection is required in relation to that creditor. Similarly, if we have somebody who might otherwise be protected by what we're talking about who volunteers to be on the committee, then I don't view that the protections on a go forward basis would be relevant, because again, that's a voluntary participation in a process and parties ought to know who the committee members are. And similarly, it's in the same vein, if we have a party who I can't, frankly, imagine this happens very often, but if we do have a party that files a notice of appearance and it's not by counsel, it's by the actual party, and the party identifies their contact information. Similarly, here we've got a voluntary effort by a party in interest, and at that point, if they've put their address information out there, again, go forward, there's no basis for continuing protection. So that's, I think those are the categories of where we would have a sort of elimination of the on a go-forward basis from and after the filing of one of those things for protection to be provided. And I know that you can wordsmith that to make that make sense. It's not going to be a day one issue, but it will be a go-forward basis if we have any of those circumstances arise. The final comment I'll make is that we do need to make it very clear in the order that if any party in interest in good faith believes that they need to have all complete addresses of creditors, and here I am kind of talking about creditors, because if we're talking about individual employees and HIPAA-protected patients, the only way that I could see them really being involved in the case is if they're asserting that they do have a claim right. So again, if we have a party in interest that in good faith believes that they are required to serve all creditors with some type of a pleading, we need to have something in the order that makes it clear that the debtors will provide that information, and that the recipient will be subject to all to care for that information in the same manner that is required by law to ensure that all HIPAA information is protected, and that they are essentially managing that information in a way that is consistent with the order. Hopefully that makes sense. What I'm trying to make sure here is that if we have a party in interest that believes that they've got to serve something on the bigger universe, but so they've got to have addresses, that they can get to it, and the debtors will provide it so long as they in good faith believe that they need it, but that they in turn will be subject to all of the same protections and limitations that are approved or provided for in the order, if that makes sense. So with those caveats, I'll approve that aspect of the motion as well. And let me, I guess, pause and ask if anybody has any questions, because I know I kind of rambled on there for a while. Okay. Well then, Ms. Fleming, I'll look for you to kind of do your magic with your colleagues, whoever's been working on this, to massage that into a form that complies with what I've talked about. If you'll just run that by Ms. Kippis so that she can also take a look at it before you upload the finalized order, and then we'll get that order entered once we see it.
Absolutely. Thank you, Your Honor. All right. The next item on our agenda was our critical vendor motion filed at docket number 25. We're also going to skip that motion for today, pending cash collateral agreement. So we'll move along to the retention application for BMC to be employed as claims agent in this case, which was filed at docket number 21. BMC is a Chapter 11 administrator with significant experience in large, complex Chapter 11 cases. They've developed efficient and cost-effective methods to handle voluminous mailings associated with noticing and claims processing portions of Chapter 11 cases. In this case, before selecting BMC, the debtors solicited price estimates from 3 different claims agent companies and ultimately chose BMC because, among other reasons, their rates were the most reasonable, and BMC, unlike other claims agents, has never had any issues with inadvertent disclosures of protected health information, which is of the utmost importance in these cases. The services to be provided in this case is the distribution of required notices and documents, the maintenance of an official copy of schedules, and the core mailing list prescribed in Bankruptcy Rule 2002, the processing of proofs of claim, the maintenance of the official claims register, and providing docket updates via the BNC website. The debtors have paid BNC an advance retainer in the amount of $15,000 pre-petition to serve as the retainer for potential retention. And before this hearing, the U.S. trustee has sent us over some comments that we are happy to incorporate in a revised form of order. In addition, the U.S. trustee has asked for a revised declaration to the application, just showing which exact parties were searched for conflicts. And we are happy to do so today. And we will ensure that the U.S. trustee has no further comments before we submit that revised form of order to your chambers for entry. With that, Your Honor, unless the court has any questions, we would submit the emergency BNC retention application to this court for entry, pending any objections from any parties in interest.
All right, Ms. Kippis, anything you wish to add?
Your Honor, I very much appreciate BNC's and the debtors reviewing the U.S. trustee's comments this morning and accepting them. If the court wants to know what they are, I'm happy to share them, but the court will probably see them in the form of order. They were fairly little nits with regard to certain terms in the engagement agreement that the U.S. trustee believes should not apply in bankruptcy or should be slightly altered because we are in bankruptcy. And I do appreciate the agreement to file the declaration with the list of conflicts parties searched. Pending seeing the new order and the new declaration, the U.S. trustee has no problem with the employment of BNC.
All right, does anybody else wish to be heard in connection with the debtor's request to employ BNC? All right, and let me ask probably what is the obvious, I know the obvious answer, but let me just make sure that we're all on the same page. Have the modifications that have been worked through, Ms. Fleming, I assume have those been floated by Ms. File to make sure that BMC is on board as well?
Yes, absolutely. All parties are in agreement.
Okay. All right, great. Then with the announced statements that there are some modifications that have been worked through, and I know just from experience with the U.S. Trustee's Office, the general nature of the types of comments. I guess I would say if there's anything unusual or non-customary, probably it would be for the benefit of other parties in interest if you all wish to state what those are. But if it's just customary stuff, I'm not really worried about the customary tweaks that ordinarily will be made in connection with the proposed forms of order.
Your Honor, I think there are usual stuff, but I can run through them pretty quickly because there aren't many of them. With regard to Section 4B, we requested that any changes in fees be with notice to the court and other parties in interest. With regard to Section 4F, we requested that late charges not be charged in bankruptcy. With regard to Section 4H, we just asked whether they had received the retainer pre-petition, and they did. With regard to Section 8, we asserted that there should be no arbitration while the case is pending and that this court should be the venue for any disputes that may arise during the pendency of the bankruptcy case. With regard to Section 13, we requested that any termination of the agreement be with notice to the board of parties and interest. With regard to Section 15, we requested that the indemnification exclude gross negligence, willful misconduct, and criminal acts. And with regard to Section 20, we requested that any assignment of the agreement should be with notice to the court, and if any new claims noticing agent is brought in, that they should file a new application for appointment. That's all.
All right, very good. No, I appreciate flagging all of those items. I think they're totally appropriate. It sounds like everybody's on board with that, which is helpful and good. So thank you for going through that. I think that's actually helpful, frankly, to other parties as well, just so that they know in future cases as well. I think all of those comments are entirely appropriate, and it would be a good model going forward. So with those modifications noted and subject to the filing of an amended or supplemental declaration to just identify the searched parties, and with Ms. Kippis being comfortable that that covers the disclosure item that she was focused on, I will approve the application. And again, given the fact that noticing is critical to get moving immediately and for the claims administration process to be jumped on immediately, I do find cause for the immediate consideration of this requested relief for Bankruptcy Rule 6003 purposes, and otherwise adopt any additional findings included within the proposed form of order. If you all will just work on finalizing that order collectively, and then if you'll get that uploaded again, first thing we need to do is get that supplemental declaration on file and make sure that Ms. Kippis is comfortable that that covers the landscape in terms of the supplemental disclosure. And then if you'll upload a form of order on that, we'll get that entered right away.
Thank you, Your Honor. That's all from me. So I'd just like to thank this court again for allowing us to appear. And I'll hand you over to my colleague, Dan McGuire, who will cover our cash collateral motion. Thank you.
Okay, very good. Thank you. All right, Mr. McGuire, you're up.
You're on mute, Dan. Dan, open the mic.
Good morning, Your Honor. Thank you for hearing us virtually. Appreciate that. Your Honor, I'll be very brief here since almost all of my presentation has been stated by others, and findings that I was looking for in connection with this motion you already found in connection with the wages motion. But initially, Your Honor, as was noted by Mr. Walsh, we are seeking a very limited bridge order here today with respect to cash collateral, and it is consensual. Right before the start of this hearing, about 9:28, we uploaded to Chambers a proposed form of order for today's hearing. It's very discreet and really just covers the items that were discussed. Briefly, by way of background, that's mostly already been covered. Our primary pre-petition secured lender, TriplePoint, asserts a lien on substantially all of the debtor's assets and is owed $30 million in principal plus interest and other charges as of the petition date. They consent to our use of cash collateral today for the discrete purposes that are set forth in the proposed order. And what that provides, Your Honor, is that the debtors can use up to $850,000 solely for payroll and employee-related expenses. And we've clarified in the order that, to the avoidance of doubt, it's only ordinary course payroll items consistent with our historical practices, and it excludes any bonus, retention, severance, or other similar payments. Those are not being authorized or approved today. And our proposed budget shows $846,000 in these payments due today, so we have built in just a few $1,000s in cushion in that, Your Honor, in case the numbers shake out slightly differently. But we're looking for exactly the money we need just to meet payroll today while we continue to work with TriplePoint on what we hope will be a consensual, longer-term use of cash collateral next week. In exchange for the use of cash collateral, we are providing them adequate protection liens and acknowledging their 507B claims. The adequate protection liens are limited pursuant to paragraph 3A of our proposed order to the category and type of collateral that they had a lien on pre-petition. And I thank Ms. Kippis for reviewing the order and making her comments this morning. We provided her the order this morning, and she reviewed it and provided comments before I'd finished my first of my 3 cups of coffee. So I greatly appreciate that she jumped on it this morning and gave us her comments. I do have to note, Your Honor, much to my chagrin, there is one typo in the proposed form of order. In the penultimate line of paragraph 3A, it says extend.
So let me,
should say extend.
let me just, sorry to interrupt you, but let me just, I need to catch up with you all because I'm not sure that I have the order that you're talking about. So, because you've indicated that you uploaded an updated order, is that, or did I just misunderstand you? Because I have the interim order that was included, the proposed interim order that was included as Exhibit A to the motion, which is, so we're talking docket number 31-1. Is that what you're referring to, or is there some new form of order that's floating around?
Your Honor, there is a new form of order that shows is uploaded at 9:28 to Chambers. I'm looking at the receipt from our docketing department that did it.
Okay, all right, so sounds like it was uploaded to our order queue. Is that what you're saying?
Well, I'm going to get over my skis here
Okay.
when I answer that question. The thing says single order upload. It lists the main case. It says new document, cash collateral interim order.pdf was uploaded successfully on 4/21 at 9:27 a.m. Order type other, related document 31, which is the cash collateral motion.
Okay, just bear with me for a moment because I need to.
I'm sorry, Your Honor. I'm just reading from the PDF that I have. It's the entirety of the information I have, and I'm.
No, that tells me what I need to know. It's been uploaded
Okay.
into the order queue. It sounds like, but it hasn't made its way to my queue. So let me just find it so that we can be looking at the same thing.
Okay. Thank you, Your Honor.
Okay. Okay, you're going to find this a little comical, Mr. McGuire. Good news is I've found it. The bad news is that the reason that I couldn't find it initially is I think it got kicked by our clerk's office staff for some reason. I have no idea why, but let me just pull it here. Well, that's not necessary. Okay. All right. All right. So apparently it got kicked because we didn't have the follow-up interim hearing included, which is fine. Main thing is that we have it. I found it. Okay. So please go ahead.
Did we do anything wrong, Your Honor, so I can make sure we don't make the same mistake in the future?
No, it's all right. You know, it's just sometimes these things happen. When they see blanks in orders, I think they kind of, the normal protocol, because we have, as you can imagine, many orders. We generally have about, on a judge basis, I think between 250 to 300 orders submitted every week. And so you don't have the same docketing clerk necessarily involved with each particular case. And I think whenever their normal protocol is if they see blanks in an order, they assume that the order hadn't been completed and they kick it back and it'll say order isn't complete. So somebody within your office is going to have received an email that said, this order has been kicked back. That's fine. We'll be able to insert into the blanks what we need, and then it can just be re-uploaded, and we'll be off to the races. So,
okay, terrific. Well, this form of order, Your Honor, has been shared with the United States trustee and TriplePoint, and as I said, this is a consensual and very limited use that makes very limited findings relative to the what I would call typical things relative to venue and jurisdiction notice and the fact that we have consent to the use of cash collateral. The relief itself, as I said, is very limited. Paragraph 2, limiting it to $850,000, clarifying that it's just for regular payroll and the related items and not things such as bonuses, retention, etc. And the adequate protection granted is also fairly limited in paragraphs 3. 3A is a replacement lien, but it is limited to the types of collateral that the lender had lien on pre-petition. So it's not broadening that for this very limited purpose. As I noted, I have a little typo there in the penultimate line. Extend should say extent. And then just a recitation of what really is the statute, 507B, that if there's diminution, they have a claim for that. So, Your Honor, as I said, I was considering a proffer with respect to cash collateral, but Your Honor actually already made all the findings relative to what I would be seeking evidence on in connection with the wages motion, which is the necessity of getting the employees paid today, which is really important to us. And, we use, as any company this size would, a payroll processor. So it is very urgent that we get this order entered and get it entered promptly so that we can get the money moving and get it into our employees' bank accounts here before the day is over. So I won't belabor this because, as I said, all the points have previously been made by others and Your Honor. So with that, Your Honor, if any questions you have, we would request entry of this very discreet cash collateral order and for the setting of a hearing next week to have a further interim hearing with respect to cash collateral, which will hopefully be consensual or if not be a non-consensual hearing.
All right, thank you. Does anybody else have any cross-examination, in relation to the cash collateral request or otherwise wish to be heard in connection with the cash collateral motion?
Your Honor, I apologize. Before you do that, I forgot to make one point, if I could, just so I
Sure.
can complete that before we open to others. I forgot to indicate on the record that none of the cash collateral we'll be using would be asserted cash collateral of AmerisourceBergen Drug Corporation. As you heard earlier, they assert a lien over proceeds of approximately $100,000 of inventory at one of the debtors, MedPro Pharmacy, LLC. To the extent any of the cash we are holding would be alleged cash collateral of that entity, we will not be using that to fund these payroll expenses. Thank you.
Okay, thank you. So going back to my earlier comment, any cross-examination or wish to be heard?
Your Honor, Darren McDermott for TriplePoint. No cross-examination today. Just wanted to make sure that we reserve our rights, of course, for the next interim hearing. To the extent that it's contested, I suspect it will be evidentiary, but nothing for today, Your Honor. Thank you.
All right, thank you.
Your Honor, if I may, for Michael Yerkowitz on behalf of Amerisource Bergen. Sorry for the tag teaming between me and Mr. Brandsburg. Thank Mr. McGuire for the representations. That is essentially our concern that our cash is not being used. Also had the concern that none of the liens being granted are going to prime what we believe are our first liens. With those representations, we wouldn't oppose the motion. Obviously, we would look forward to being included in the discussions as to the next order that would be entered as well.
All right, thank you. Any other comments?
Your Honor, Meredith Chippas, on behalf of the United States trustee, I want to confirm that I did review that form of order and apologize to Mr. McGuire for not catching the typo. But for this limited purpose today, this order is fine, and we look forward to seeing a more complete and full cash collateral order in the future. And of course, we also reserve all rights with regard to future cash use in terms of the future cash collateral order.
Okay, thank you. All right, any other final comments? All right, then we will pin down a further interim hearing date here in a moment. But again, for purposes of the record, obviously this is, in as much as it does relate to employee-related matters, is something appropriate for consideration to avoid any irreparable harm to the estates pending a final hearing, and here pending even our further interim hearing, that the requested relief is substantially appropriate for purposes of interim approval under Bankruptcy Rule 4001 B2. I am, however, not going to approve on an emergency hearing basis, and I don't think that we have an evidentiary record that would support it, the granting of adequate protection liens on Chapter 5 causes of action or proceeds of Chapter 5 causes of action at this point in time. Usually in this district, we will leave that for a final hearing. I'm not telling you that I'm not open to considering it at the further interim hearing, because at least there would be a little more notice. But I'm just going to tell you all that if there's ever going to be a grant of liens on avoidance actions or proceeds of avoidance actions, I'm going to want to have an evidentiary record as to why that is necessary in order for that relief to be granted. And certainly, you know, even in connection with the final hearing, I would need an evidentiary record as to why liens with respect to those items would be necessary. So that's the only exception that I'm going to note. Otherwise, I'm perfectly fine with the proposed form of order, and it will be approved on that basis.
Your Honor, on that point, understood completely, and our belief is that the drafting of this order, the way it's written, does not give them a lien on avoidance actions. It only provides a lien on the things that are defined as adequate protection collateral to the extent such category type of collateral was included within the pre-petition collateral. And since Chapter 5 causes of action don't exist until the petition date is filed, they couldn't possibly have a lien on them pre-petition. So it was the intent, and our understanding, that this should not be including, just for clarity on the record, this should not be including avoidance actions with respect to the adequate protection lien.
Okay.
We're happy to clarification Your Honor wants.
Yeah, no, I see.
I have the advantage of having written it and read this. You just got it, 2 minutes ago. But the way it's written, I think Your Honor does exclude those because they are not pre-petition collateral.
even more to the point then, with that language included, for you to delete any reference to avoidance actions or proceeds of avoidance actions from that paragraph, because they couldn't have existed pre-petition, so they shouldn't be in the including without limitation language. Okay?
Mr. Asman is fine with that. I'm fine with that.
Your Honor, Darren Asman from McDermott for TriplePoint. We're fine with that, and we fully expected to have this heard at the final hearing. I will note that $850,000, albeit only for payroll, it does represent about 20% of the total cash the debtors have. So it is a pretty significant portion going out the door, but we understand that, Your Honor, once we're an evidentiary record, it's something that we would fully expect you to expect. And so we'll be prepared to present that at a final hearing if there is one on our cash collateral use or a potential debt.
Okay,
thank you.
Great. All right, thank you. So with that notation, then I'll approve the requested relief and authorize, again, to the extent that there might otherwise be any stays that would apply. I don't think that's really relevant to a cash collateral order, but it would be obviously approved immediately. And I know just even because we're dealing with payroll, to the extent of any concerns with respect to timing as to getting the order docketed, please consider my authorization immediately effective as of this oral ruling so that you all can get moving on processing payroll. But we'll look for the orders. As soon as we see the orders, we'll get those entered ASAP. I'll just reemphasize one thing, probably for your benefit, Ms. Fleming. If you all can make sure that you get those joint administration orders uploaded as quickly as possible, because we'll want to get those entered before we start entering the substantive orders so that there's no question by anybody down the road. But then we'll look for the cash collateral order and the cash management system order, kind of first and foremost, to make sure we get those entered by the court as quickly as possible. Okay? Next interim hearing. So you all have you're going to be the beneficiary of the fact that we actually have an internal judicial FJC training conference, a bunch of next week that I decided to forego because I'm too busy. So the time that I was setting aside to work on the stuff that I'm busy on, y'all are going to be the beneficiaries of. So tell me when you all think that, when will you be ready to follow up with an interim hearing, kind of number one, and number two, do we want to or do we need to load up that same hearing with some of the other matters that we kicked from today's docket?
So, Your Honor, if I can, Tim Walsh from Winston on behalf of the debtors. I'm looking at the 26th, Your Honor. I think that gives us time. Well, we'll work through the weekend on the budget and on cash collateral, but I think that would give us time. If it's going to be contested, Mr. Asman and I will work out a schedule for an objection, witnesses and the like, but we should be able to get ready for the 26th if it's going to need to be an evidentiary hearing. Obviously, as soon as we know that, we'll alert Chambers and let Chambers know so we can make sure that we have adequate time. And I think what we should do is we should put the rest of the matters on, of the first days on for that day as well. If it's going to be contested, it's going to be contested with respect to all of the expenditures that we need for our first days. So I think we should have them all on at the same time. If that works for the court.
Mr. Osmond, does that timing, do you think that works on your end?
The timing's just fine for us, Your Honor. I would just ask, Mr. Walsh and I will absolutely be able to work out times for objection deadlines and responses, but it would be helpful maybe for Your Honor to give us some guidance on the latest you'd like to see the last pleading filed.
Sure.
And we don't want to agree on a schedule that's not acceptable to you.
Right. No, and I appreciate that because it is helpful to know what's going on before we get there. Albeit, I realize that even then, Sometimes there are discussions that continue after the deadline. So why don't we, like I said, my deck is cleared on the 26th because originally I was going to be out of town. So why don't we, just because we do have a number of the other matters, and let's not get ourselves jammed up, why don't we plan for 9:30 a.m. Central Time? Does that work for folks?
Yes, it's good for us.
Good for us, Your Honor.
Okay, good. So what we'll do is we'll have the continued interim hearing on cash collateral on the 26th at 9:30 a.m. We'll also carry the insurance motion at docket 10, the taxes motion at docket 11, the utility motion at docket 12, and the critical vendor motion at docket number 25 to the same date and time. Why don't we just trying to think for
How does your
other parties in interest, because really what other parties in interest are going to need to know is they're going to need to see the final, well, I guess it's going to be another interim order, though, because we're still within the 14 days. But they're going to want to see what that looks like if there's an agreement. And frankly, even if there's not an agreement, then obviously TriplePoint will also want to know what's the debtor's proposed form of further interim relief. So can we set a deadline of, again, I'm trying to be a little bit aggressive here and give you all as much time as possible, but could we say 5 p.m. Central Time of the circulation of the proposed form of order, whatever it's going to be, on May 2nd, so Tuesday, May 2nd? And I'm sorry, I'm in the wrong week. And that's not going to work. I'm sorry, I don't know how I ended up in that week on my calendar. Can we have a deadline of 5 p.m. Central Time on Monday, the 24th, for the proposed form of order, and then set a deadline for any objections to that order by any party in interest? And if we're going to have an objection to the cash collateral relief, if it's going to be opposed by TriplePoint. So basically an all-in objection deadline by parties in interest of 5 p.m. on Tuesday the 25th Central Time. Does that, I know that probably makes it most difficult for your team, Mr. Walsh, but at the same time realizing that, we don't have a lot of time between now and the 26th, so I'm trying to give as much flexibility as I can.
I appreciate that, Your Honor. We'll deal with the time constraints, no problem.
Yeah, Your Honor, we're good with that schedule. That makes sense given the constraints here.
Okay, so I guess the only thing that we haven't talked about is if there's going to be a designation of witnesses and exhibits. I mean, you all will know where you're at, frankly, so go ahead.
You're not, sorry, Your Honor. Mr. Asman and I will be able to work that out. If there's a third party that has an objection and has a witness, I would just ask that they reach out to us and we'll get something scheduled. But I'm not worried about reaching an agreement with Mr. Asman on witnesses and witness lists, and we've worked together for many years, so we'll be fine.
Okay. Just for my benefit, though, I'm not going to get in the way of y'all. But for my benefit and probably a little bit for the U.S. trustees' benefit at a minimum, like I said, I'm not going to get in the way of what y'all are trying to accomplish, but just know that I really need a little bit of time for us to get things in order for the hearing. I guess in some respects, if you all know who's who and what the exhibits are going to be, that's fine. If people are going to be here, you can bring them. But at some level, if we're going to have exhibits for a hearing that, and we're doing it all remote, somehow you all need to get the exhibits to me. Because I try to be reasonably flexible with electronic stuff, but quite frankly, it can be very cumbersome trying to navigate through multiple screens, without tangible documents. And while we try to be flexible in terms of printing stuff, the comment I often make to folks is just for out of an abundance of caution, if anybody is unclear on this, we are not Kinkos, so we cannot print stuff, large volumes of documents in a short period of time. So again, if there's going to be a lot of documents, it would be very helpful for you all to get those to us in advance. So.
And Your Honor, from the debtor's perspective, I suspect that if it's going to be a contested evidentiary hearing, that we'll be there live.
Okay.
That should make it a little bit easier.
All right.
So, Your Honor, is there a deadline by which you'd like to have the witness list and exhibits? I want to make sure you've got what you need in advance of the hearing. Do you want to maybe say like noon the day before?
Well, if the objection deadline is going to be 5, I'm inclined to say, why don't we target 5? But what I'm also telling you is, I realize that things may be still moving a little bit at that point. So maybe if you can just do a placeholder, if you're still talking, do a placeholder by 5 so that other parties in interest also have a sense of what's there, what the baseline documents are, and that sort of thing. But realizing that, it may be amended between 5 p.m. on Tuesday and the start of the hearing at 9:30 a.m. the following morning, if that makes sense. I mean, probably like the classic example is if you all are still in negotiations with respect to the budget, it may be that we have an amended budget that gets ends up being filed as part of a supplemental witness and exhibit list or an amended witness and exhibit list or what have you. But I think if you all can at least designate what we've got by the time of 5 p.m., that would be helpful to both my staff and also Ms. Kippis and her group. And other parties in interest as well. I don't mean to shortcut anybody else, but I know we'll all be looking for it.
Okay.
All right.
Fine, Your Honor.
That makes sense, Your Honor. Thank you.
All right. Very good. Well, thank you. And I'm also, by the way, I didn't want to try to wordsmith our interim order. I'll just note for purposes of the record, and I'm also accepting for purposes of the record the representation that in relation to Amerisource Bergen, that in fact the cash collateral that's proposed to be used is not any cash that's claimed as cash collateral by Amerisource Bergen. I think that that's what everybody agreed to as part of the proceeding, so that we don't have to worry about Amerisource Bergen issues for today. That may be something that we have to work through in connection with next week, but for today's purposes, we don't have that issue. Is that fair? Everybody on board with that?
Yes, Your Honor.
Yes, Your Honor. Acceptable to Amerisource.
Okay. All right. Then if you'll work into the interim cash collateral order, our next April 26th date, and then re-upload that, have your folks re-upload that. We'll get that entered as soon as we see it. I don't think we need to work, I guess, why don't you work into that order the objection deadline of, both the proposed final, or I keep saying final order, the proposed further interim order deadline of Monday at 5 p.m. Central and the objection deadline of Tuesday 5 p.m. Central. into the order as well, that would be helpful, just so that other parties in interest will also be aware of those deadlines. And then I think that should take care of everything that we need for the interim order purposes. Any questions or concerns from anybody?
Your Honor, Meredith Kippis for the U.S. Trustee. This is just for information for the parties who are preparing forms of order. I am going to be in another set of first day hearings at 2 p.m. in front of Judge Everett. So to the extent you send me orders after 2 p.m., I'm not going to be able to respond to you very quickly. But we'll get to them as soon as I can after the hearing is concluded. And if there are things that you need for me to look at before 2 p.m., I would very much appreciate it if they were sent to me before 1:30. Thanks.
Well, that will definitely be the wage order. We definitely need to get that one done.
Sounds good.
Excellent.
All right, anything else we should touch base on today, Mr. Walsh?
I think that's it, Your Honor. Appreciate the courts giving us the time on short notice.
Okay, very good. Then we will see you all next week on the 26th at 9:30 a.m. Central Time. And that will conclude, for today's purposes, our hearing in the Pill Club Pharmacy et al. Cases, and the court will be in recess.
Thank you, Your Honor.
Thank you, Your Honor.
All rise.